rise.
Kosovo Specialist Chambers is now in session.
Good morning, everyone. Welcome. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Gucati&Haradinaj.
No change, Your Honor.
Okay, I'm sorry. Mr. Cadman?
No change, Your Honor.
Today we will hear the opening statements of the defense for Mr. Hisni Gucati, pursuant to Rules 126 and 127. Before we start, for the benefit of the public, I recall that the panel held the defense preparation conference yesterday. Further to the submissions of Mr. Rees, the panel has scheduled the opening statement of the Gucati defense for today, December 3rd, 2021. The panel recalls that in accordance with Rule 26, Paragraph 1, opening statements shall be made orally and shall be restricted to a principal overview of the subject matter of the case. They may also provide a concise explanation of the evidence to be called and how it impacts the issues in the case. Presentation of the evidence of the Gucati defense case will start on Monday, December 6, 2021, with the testimony of Mr. Gucati. Mr. Rees, you have the floor.
According to law, this institution is an institution of the independent and sovereign Republic of Kosovo. It is right that the people of Kosovo expect it to act as such. The modern Republic of Kosovo places the highest value on the freedoms of speech, expression, and opinion. Those freedoms were won by Hisni Gucati's generation with the sacrifice of their flesh and blood. In acknowledgement of that sacrifice, the modern Republic of Kosovo demands that its institutions act with openness and transparency, that daylight is shone into all four corners of their administrative and judicial bodies. The law on classification of information in Kosovo is clear. Classification of information as restricted or confidential or secret shall not be used as a tool to conceal violations of law, abuse of authority, inefficiency or error, or to prevent embarrassment to a person, public authority, or organization. The days when the authorities might quickly pull down a curtain of secrecy, whether physical or virtual, between themselves and the public gallery of the people of Kosovo, whenever the authorities sought to avoid public scrutiny, ought to have been confined to the distant past. To be frank, it is disingenuous to say to those who doubt, as the specialist prosecutor does, watch our work, then judge us, at the same time as seeking to control what the doubters see of that work, making visible to the public only a highly sanitized and censored version. Moreover, the present and future for Kosovo ought to be one where justice is for all, not just for some. The specialist prosecutor, in his opening statement, paid lip service only to these most important values. Vigorous debate on important public signs. Vigorous debate on important public issues is a sign of a healthy society to be fostered and not suppressed, the specialist prosecutor acknowledged. It is okay to say what you do not like about this court, and it's okay to say why you do not like this court, he continued. That is all part of a free society, he agreed. Such seemingly reasonable words from the specialist prosecutor do not extend apparently to Mr. Gucati and his co-accused. For Mr. Gucati, his words are turned against him by the specialist prosecutor, who labels Mr. Gucati as a vocal opponent of this institution, as if, despite his earlier concession to the right to freedom of speech, that in itself is an offence. The evidence makes clear, we submit, that the specialist prosecutor seeks to pick and choose who he deems worthy of enjoying the right to freedom of expression. And Mr. Gucati, a vocal opponent of the SPO, is not one of them. Mr. Gucati has indeed been vocal about his concerns of this institution. He was and is entitled to be so. He has set out why he has concerns. He was and is entitled to do so. I will return to those wider concerns shortly, because they are shared by others. One matter that he has been vocal about is that the Specialist Prosecutor's Office does not pursue justice for all, but only for some. The Specialist Prosecutor's claim in his opening statement that this court should be a victim-driven court is undermined by the actions of his own office, which pursues not the path to whoever's door the evidence of criminal offending may lead, but rather its own mandate or agenda. It is both arrogant and incorrect in equal measure for the SPO to assume that the direction it travels to pursue that agenda is the same in all respects as the direction travelled by the true course of justice. Look at the evidence we have already heard and received in this case about the concerns shared by others and indeed published by those persons online, where they remain in full view to this day. We saw at Exhibit P74 and P74ET the article by Gazeta Newborn, headlined "Scandalous. The Specialist Chambers collaborated even with Serb MUP Ministry of the Interior to arrange witnesses to testify against KLA." The article continued, "New evidence shows about a scandalous process carried out by the Specialist Chambers regarding its accused people who are KLA members. A document found by Gazeta Newborn shows that this court has cooperated with Serbia's MUP in order to secure and find as many witnesses as possible against those accused who are KLA members." We looked at Exhibit P124 and P124ET, the translation. This article was headlined, again, "Specialist Chambers Scandal." It cooperated with Serbia army officers who were also active during the time of Milosevic. The article continued, "Other documents speak of the cooperation the Specialist Chambers had with Serb officials who were in active duty during the time of the butcher of Balkans, Slobodan Milosevic. Dusan Karinovic and Veljko Lojanica are two names of Serb officers who were present in some of the macabre massacres committed in Kosovo by the Milosevic regime. Newborn newspaper obtained the document showing that these Serb officers were contacted by the Specialist Chambers in order to give testimony against KLA and its members. Who will seek justice for the victims of those macabre massacres at which those two named Serb officers were present and active? Not the SPO, which instead courts their cooperation to pursue its own agenda. Within the same exhibit, we looked at another article, this time headlined, "Jakova, former police commander Milan Stojanovic, collaborator of Specialist Chambers." Although they wake up every day in panic in anticipation of news about their loved ones, the journalist wrote, it has been over 2 decades and no information has been passed on about the Jakova disappeared persons. However, it appears that Jakova, former police commander, during the rule of Milosevic, Milan Stojanovic, is a close collaborator of the Specialist Chambers, despite the fact that he is responsible for the Maya massacre in Jakova. Former Commander Stojanovic is cooperating with the Specialist Chambers in order to find evidence against the former KLA soldiers. Newborn newspaper obtained a document confirming the collaboration of Stojanovic with the specialist chambers? Who will seek justice for those persons in Jakova who disappeared under the watch of Milan Stojanovic? Not the SPO, which instead courts his collaboration to pursue its own agenda. Who will seek justice for those persons murdered in the Meyer massacre under the watch of Milan Stojanovic? Not the SPO, which instead courts his collaboration to pursue its own agenda. We watched the video exhibit P123 with pictures of the cemetery in Meyer. And we listened to the narration. The 27th of April marks the day when 376 civilians, including women and children, were murdered in Meyer. Children from 1.5 years old, as well as women, were initially executed and then burned inside a house by the Serb forces. The specialist chambers requested the assistance and collaboration of the former militia commander in Jakova district, Milan Stojanovic, against the KLA. And we saw, as we watched the images, the subtitle, the main person responsible for the Meyer massacre, Stojanovic, the person who should be in prison, is collaborating with the specialist chambers instead. Who will pursue justice for those 376 civilians, including women, children, and infants, who were murdered, executed, and burned inside a house by forces under Milan Stojanovic's control? Not the SPO, which instead courts his collaboration to pursue its own agenda. We looked at Exhibit P128 and its translation again within P124ET of the article headlined, "Specialist Chambers Cooperated with Person Wanted by Interpol for War Crimes in Kosovo in order to find evidence against the KLA." New evidence is coming out about the work of the specialist chambers and its cooperation with persons accused of war crimes, the journalist wrote. Newborn newspaper obtained a document which shows that a person wanted by Interpol for war crimes in Kosovo seems to be a witness against the KLA in the specialist chambers. In 2005, as the trial of the butcher of Balkans, Slobodan Milosevic, was proceeding in The Hague, the face of Kosovo Albanian Muharrem Ibrai also appeared in the cameras. He was a witness for Milosevic. Muharrem Ibrai, the journalist continued, comes from one of the areas where the most terrible crimes were committed by the Serb state apparatus. And then he went to The Hague to defend Slobodan Milosevic. Muharrem Ibrai is accused of crimes and rapes during the war in Kosovo. Similarly, Ibrai is one of 17 people wanted by Interpol for war crimes, and the only one with Albanian ethnic background. And they provided then the list of 17 Serbs and 1 Kosovar wanted by Interpol for crimes in Kosovo, some of the names of which we will deal with shortly. Who will pursue justice for the victims of the crimes, the rapes, Muharrem Ibrahim committed during the war in Kosovo, not the SBO, which instead courts his collaboration to pursue its own agenda. We saw Exhibit P125 and its translation at Exhibit P125 ET3 and the article entitled "Scandalous. Special Court Requested Incriminating Materials on Adam Yashari." The Special Court has requested from the Serbian Prosecution Office incriminating materials on Adam Yashari 17 years after his fall, published RTK. In March 1998, after several days of resistance in Prekaz, the commander, Adam Yashari, and 60 members of his family were killed. The attack of Serbia's Special Unites on the Yashari's family in Prekaz, which led to the brutal killing of Adem and Hamaz Yashari and their family, was condemned by Amnesty International. The massacre against the Yashari family in Prekaz, like in many other massacres, was carried out by regular police forces, amongst which, over 21 years later, no one is held accountable for. Even though the names of those in the chain of command are known, starting from the policeman to the President Slobodan Milosevic. No efforts were made by international justice to adjudicate the Serb criminals and serve justice for such barbaric murders. However, RTK commented, on the 11th of June 2015, the opposite happened. Among thousands of exclusive leaked documents of the Special Court, there was a letter in which the lead prosecutor, David Schwendeman, asked Serbian former war crime prosecutor Vladimir Vukcevic to provide him with documents on Adem Yashari. In his letter, the article continued, Schwendeman wrote that pursuant to the ongoing coordination and further to a meeting held on the 1st of June 2015, he asked Serbia's War Crimes Prosecutor's Office to provide him with copies of cases related to terrorism of organised armed groups committed by Kosovo Albanians in the period 1981 to 1999, mentioning specifically the names of Adem Yashari. He, together with 60 members of his family, were inhumanely killed in their house, specifically by Serbian forces, 17 years before this request for incriminating materials took place. RTK quoted from the letter directly, "Furthermore, I kindly request that, if possible, the first documentation to be delivered should be regarding the case KT number 139/96, judgment K number 37/97, adjudicated by the District Court of Pristina against the following individuals," naming 10 individuals, including Adem Yashari. RTK continued, "The state of Serbia has committed over 400 inhuman massacres against Albanian civilians in Kosovo. It has cruelly killed around 13,000 innocent civilians, amongst them around 1,300 children. Serbian police and military forces have raped over 20,000 Albanian women and evicted over 1 million Albanians from their homes. In their attempt of ethnic cleansing, they have burned and destroyed most Albanian properties. The article concluded the requests of international justice to investigate the victims of cruel massacres by Serbia's regime, crimes that have never been solved, are insults and injustices for those victims themselves, for their families, and for the Albanian people. Who will pursue justice for those 60 victims of the Yashari family murdered at Prekas? Not the SPO, which instead courts those agencies responsible for that massacre for their collaboration to pursue the SPO's own agenda. During the course of the defence case, we will adduce further evidence about other names that it is said by the SPO that they sought cooperation from, including Nebojša Trajković, known as Lutka, the well-known deputy chief of Glogovts and the OUP unit of internal affairs within Slobodan Milosevic's Serbian ministry. Glogovts, now known as Drenas, was the site of numerous executions, beatings and robberies by Serbian security forces in spring 1999. And Trajković has been publicly named by Human Rights Watch as the principal organizer of the forced depopulation of the village of Drenas in May 1999. We will adduce evidence of Bogdan Peric, an individual publicly named by the EU under the EU Council Decision 1999/319/CFSP, implementing the Common Position 1999/318/F, which put in place restrictive measures against the Federal Republic of Yugoslavia, naming Bogdan Peric as the mayor of Gilan and a known associate of Slobodan Milosevic, banning him as a person whose activities were close to and supported the barbaric regime of President Milosevic. And we will adduce evidence of Branislav Radic, or as Ms. Pumper said, also known as Branislav Rakic, part of civil protection in Faritsai in April 1999, when the Kosovan Albanian people there were subject to mass expulsion. Radic, or Rakic, is somebody who remains wanted by Kosovo police for crimes, but is courted for his collaboration by the SPO. The matters that lay behind the concerns expressed in those exhibited articles by Gazeta Newborn, by Top Channel, by RTK, and other broadcasters, only came to light because the press had access to documents that the SPO now suggests should have remained hidden from their view. Other individual journalists shared those concerns. Within Exhibit P11ET, the journalist and politician Berat Bozala expressed his concern. I voted for the formation of the Special Tribunal, but I wouldn't have voted for it today. Milovan Drecic, I'll say it again, Milovan Drecin is the Serbian collaborator with the Hague Tribunal. And I am old enough to know who Milovan Drecin is. This is not the way to bring justice. Justice cannot be brought about with the help of Milosevic's apparatus. President Vučić himself has admitted that the Serbian security forces have killed Serbian civilians with a view to blaming Albanians. And he referred to the murder of civilians by the Serbian security forces in the notorious Panda incident. He continued, how can you not only collaborate, but claim to bring justice for war crimes in Kosovo with the same bodies that have killed their own civilians? For me, this is completely unacceptable. This distorts the reality for which this process started. In the same breath that the specialist prosecutor deprecates the expression of those very same concerns by Husni Gucati, the specialist prosecutor sycophantically praises the media in Kosovo, directly assuring the civilian witness Halil Berisha that he had done nothing wrong. In the SPO's clear assessment, no crimes were committed by Mr. Berisha, and of course we wholeheartedly agree. Consider, though, his evidence and compare and contrast his position with that of Husni Gucati. At the end of the first press conference, Mr. Berisha told you that he and his cameraman took images of the documents. He created, in contrast to Mr. Gucati, he created and told you copies of this documentation. His media organization, In Focus, broadcast the contents of the press conference on social media, giving airtime and publicity to those remarks made by Mr. Gucati and his co-accused that the SPO attack and criticize. He, Mr. Berisha, asked to take the documentation itself. He wanted to take all of the documentation to look at in its full and unredacted form, and he took about 1,000 pages of it, having carried out an initial review of its contents at the KLA WVA headquarters. He physically removed the documents from that office, and he carried them to his own offices at the In Focus newspaper, where, like Mr. Gucati, he made the documents available to others, to professional journalists, just as Mr. Gucati had done, albeit at Mr. Berisha's offices, where he discussed their full and unredacted content with his co-editors. 4 of them. He made those documents available to those 4 other persons without any redactions. And like Mr. Gucati, Mr. Berisha oversaw the creation of more copies of the documents at the offices of InFocus, taking further images of them in full. The copies of the documents that he, his cameraman, and his other co-editors made were created in digital form, and they have never been retrieved by the SPO. Indeed, the truth is, the SPO have never cared to ask for them. They've never sought to retrieve them. They've never shown any interest in retrieving them, despite the articles published by InFocus being perfectly transparent and making the existence of digital copies of those documents in InFocus's possession plain for all to see. And like Mr. Gucati, Mr. Berisha and his co-editors published copies of the documents on the internet for all to see, where they remain to this day. The SPO have never asked InFocus to remove the articles and shown no interest in those articles being removed, even after their continued presence on the internet was brought firmly to their attention if they were not previously so aware. Mr. Berisha reported that the files contained Serbian, Albanian, Roma and Ashkali names, something the SPO specifically criticizes Mr. Gucati for saying. He reported that the cooperation between special investigators and Serbian witnesses and officials was evident in these documents, and that the SITF was principally in contact with Vladimir Vukcevic, former Chief War Crimes Prosecutor, and also Milovan Drecin, head of the working group looking for facts about war crimes. It was in the public interest to so report, Mr. Berisha said in evidence, because, in his words, these persons are high Serbian officials and were the persons that a part of the people in Kosovo know due to their statements, so these were not private persons. Since they were mentioned in these documents, we deemed it necessary to publish them and their identity, he told the trial panel. He quoted directly from letters from Kwai Hong Ip of the SITF to Vukcevic, attaching a list of persons that the SITF wished to interview. Mr. Berisha did redact the names in the list for the purpose of publishing the article online, but only after he had shown the unredacted list to colleagues at InFocus. Going further again than Mr. Gucati, Mr. Berisha published a letter from the Serbian Parliamentary Committee on Kosovo and Metohija, as they call it, to the SITF dated the 17th of November 2015, this time printing the letter in full. He was asked why. There are many reasons for that, he told the trial panel. One of the reasons for that is that each Kosovan citizen born before 1996, they know the crimes that the Serbs committed in Kosovo. And in spite of the fact that Kosovo now is an independent nation, here the text uses the words Kosovo and Metohija, which is not the correct term. And these terms have been used in a document or a statement by Serbian officials, and this relates to the alleged crimes that allegedly Albanians committed. It was in the public interest to know. Sharing those concerns expressed by RTK, Mr. Berisha published an article on how the special court had requested evidence from Serbia against Adam Yashari and others. He was asked about why he did that, and he explained It was never mentioned that evidence was to be sought against Kosovo's hero, Adam Yashari. So when we saw this in these documents, we thought this was in the public interest to know about, because Adam Yashari was killed by Serbian forces. And I believe Kosovo citizens were expected to be collected against those who killed Adam Yashari, not on him. He too quoted extensively from that letter from David Schwendeman to Vukcevic seeking that evidence. He continued, Adam Yashari and over 50 members of his family, including young infants, were massacred by Serb forces. So we, as citizens, but as journalists too, expect that evidence would be collected against those who committed that massacre, not against the victims of it. Going further than Mr. Gucati, again, he uploaded copies of those documents, digital copies, to the InFocus system, where they remain available to everyone working at InFocus, he told you. InFocus continues to publish the same on their website. He gave a moving explanation as to why it was in the public interest to report that the SPO had placed requests for Serbia to collect evidence given by former Serbian police officers and Serbian chiefs of police stations. This was of public interest given the past of our nation, the people of Kosovo. Maybe I'm young by age, but I experienced war as well. I was 6 years old during the war. And at that time, I, my family, and other citizens were forced out of our apartment, our house. And we were forced to travel to Albania. As a 6-year-old, I had to walk to Albania without food, without water. And Serbian forces had put corpses of dead people on the way. For me, as a 6-year-old, this was horrifying. This is a theme that is discussed on a daily basis in our part of the world. That is why this was of public interest. And reporting on this issue is of public interest. In focus, Mr. Berisha himself did not hand over to the SPO any digital copies of the documents that they had retained. To be fair, the SPO's investigators have never asked, and it can be inferred that they do not care. On the 16th of September 2021, Mr. Berisha continued to publish new images of the documents, this time a full and unredacted copy of a letter headed Coordination Request number 63, again from Kwai Hong Yip to Mr. Vukcevic. Although he did not publish online the list of witnesses attached to the request, Mr. Berisha had given access to that list, unredacted, to his journalist colleagues in the editorial team at the InFocus offices. And he published in the same article a full copy of a letter headed Coordination Request number 120, addressed again to Mr. Vukcevic, stating, and he published this, that information had been provided by Dusan Dragovic of the MUP in Jagodina during the past 3 years. He was asked why he did that, and Mr. Berisha said to you, it is publicly known that even after the declaration of independence of Kosovo, members of the Serbian MUP continued to be present and active in Kosovo illegally. So this was of public interest. I repeat, the SPO stresses that Mr. Berisha has done nothing wrong, and the defence wholeheartedly agree. The matters that lay behind Mr. Berisha's concerns, as he expressed in those articles, came to light because Mr. Berisha had access to the documents the SPO say should have in fact remained hidden and not come to light. Remind you of the remarks the Specialist Prosecutor made at the outset. Vigorous debate on important public issues should be fostered, not suppressed. He claimed, it is okay to say what you do not like about this court, and it's okay to say why you do not like this court. This is all part of a free society, he acknowledged. But how can debate take place if the fundamental facts remain hidden away? The SPO shies away from confrontation with those in the press who made public and continue to their concern based on this documentation of SPO collaboration, to use the words of the press, SPO collaboration with those suspected of murder and rape and forced depopulation in order to further its own agenda. At the same time, the SPO calls no witness from within its own ranks to account for and be accountable for the burning questions as to who, how, and why this material was allowed to pass from the SPO to the KLA-WVA headquarters on not one, not two, but 3 separate occasions. The SPO closes ranks, and those in the SPO with knowledge of that process remain lurking in the shadows, protected from scrutiny by their colleagues. Despite the Specialist Prosecutor telling the public in his opening statement that the documents were stolen, the prosecution has called no evidence to support that bare assertion, or indeed any evidence at all as to what actually occurred. They say nothing about the information in Exhibit P155 and its translation P155ET that explicitly makes clear that some journalists received a copy of the so-called Hague dossier directly, I quote, from a source in the Specialist Prosecution Office in The Hague. Where the defence say that there is information that a named, currently serving SPO officer was implicated in the process by which the materials arrived at the KLA-WVA headquarters, they say nothing. And they call no evidence to dispute it. And despite the investigations, the Specialist Prosecutor in opening claims that they have conducted, the SPO produces in evidence no independent report which exonerates their own staff from being deliberately involved in the leak. They cannot do so because they have no such report. With no will or inclination to confront those in the press who revealed, using their words, the shameful collaboration between the SPO and those suspected of the most serious crimes, the SPO simultaneously refuses to allow the truth as to who, how, and why this material came to pass from its offices to the KLAWVA in the first instance to come to light. Instead, the SPO targets Husni Gucati and his co-accused with these trumped-up charges in a victimless prosecution. This is, we submit, a cowardly prosecution by a cowardly prosecutor's office. By contrast, Husni Gucati is no coward. He is, and as has always been, open, honest, and transparent. And on Monday, he will give evidence, and he will answer every question asked of him. Thank you, Your Honours.
Thank you, Mr. Rees. We will resume on Monday, 6th of December, 2021 at 9:30 to start the Gucati defense case. This hearing is adjourned.
All rise.